this can't be. Our courts can't be the catch-all because we don't get it right here. And I've heard terms like immunity. I used that term yesterday. Stop saying Section 230. They're using it as a shield. They're using it as a get-out-of-jail-free card. They're using it for immunity. And I heard join us in this fight. That term has been used. Join us in this fight. If you're not going to join us in this fight, just get out of our way. Stop being a shield. Any lawmaker that doesn't demand that COSA be brought to the floor for a vote and that we pass it, they're standing in the way between us and protecting our kids.
Ashley Moody delivered one of the most emotional moments of the hearing, demanding Congress stop protecting social media companies and start protecting children. Her message was blunt: if you're not going to join us in this fight, get out of our way.
Thank you, Senator, and I agree with you. It is time to take it to the floor and pass it. Certainly do. Senator Moody, you're recognized.
Thank you. I was the Attorney General of Florida before I became a United States Senator, and I thought the biggest challenge for me becoming the Attorney General as a mother, still having a kid in school at these very, I believe, fragile ages. I thought that was going to be the biggest challenge, but it ended up being the biggest driver to be still dealing with what I call the backpack issues while I was in a place to do something about it. Became one of my biggest drivers and inspirations and drove me every single day, because we're living through a period of technological change and innovations that what once took generations to reshape society, how we all navigate that as parents, they now emerge almost overnight. Our children are on the front lines of these changes before the risks are even fully understood, especially by those of us dealing with it every day. And we've seen this pattern before. Industries move faster than policymakers, technology outpaces oversight, and by the time the public and even lawmakers fully understand the consequences, an entire generation of children has already been irreversibly exposed to harm. The problem becomes even more troubling when companies are not merely aware of risk to children, but are actively designing their products to maximize engagement, dependency, and despicably profit. America's children are not piggy banks for big tech to shake down to satisfy their next quarterly earnings call. And that is why, as Attorney General, as the top enforcement officer in Florida, I fought back in court to end these abusive practices. We brought suit. Specifically, we argued that Meta intentionally designed features to keep children and teenagers compulsively engaged and addicted to its platforms. The response to that litigation, like Florida's, that I'm seeing all across this nation, is incredibly disturbing. They try to get cases dismissed by arguing that many of the features keeping children hooked on social media, like endless scrolling, autoplay, recommended algorithms, incessant notifications, implicate protected free speech and editorial functions under the First Amendment and Section 230. In other words, they don't only want to keep doing these obviously harmful practices, they don't want anyone to even second guess that, and they argue that they have the legal right to continue harming kids. I want to repeat that. They argue they are legally entitled to addict and harm our children, and we can do nothing about it. They don't want parents, they definitely don't want us lawmakers thinking, well, maybe these platforms don't have the best interests of our children in mind. Maybe we ought to make sure that they are protected. And what has become abundantly clear is that the private industry cannot be relied upon to prioritize the safety of children when those protections conflict with the bottom line. So it's obvious we have to do something to pass common sense legislation, because I keep hearing the word immunity. And let me just say, I showed up today and it didn't even hit me until I looked at this table and talk about emblematic moms on a mission. I mean, thank you for being here today. It breaks my heart that you're coming here after the tragic things that happened to your family, the loss of your sons. But thank you for standing up and speaking out and saying, this can't be. Our courts can't be the catch-all because we don't get it right here. And I've heard terms like immunity. I used that term yesterday. Stop saying Section 230. They're using it as a shield. They're using it as a get-out-of-jail-free card. They're using it for immunity. And I heard join us in this fight. That term has been used. Join us in this fight. If you're not going to join us in this fight, just get out of our way. Stop being a shield. Any lawmaker that doesn't demand that COSA be brought to the floor for a vote and that we pass it, they're standing in the way between us and protecting our kids. They're acting as a shield for these companies that are putting profit over protection. I would like to know if you can tell us, Ms. Lanier first, most people assume, many parents assume, that people are getting to our children because the children are seeking out actively these things. And I think we're hearing today that, imagine if COSA's duty for care had been in place in the 2 years following the choking challenge. Imagine what the parents have had to deal with that came after you if they had had that duty of care in place. So can you tell briefly to the committee how these algorithms are getting pushed to our kids as opposed to what many people believe they're going out and seeking these things?
Absolutely. Thank you, Senator Moody. These algorithms, a good analogy that one of the whistleblowers in our trial, Mr. Boland, who actually has also testified here, he told the jury, it fits very well here. Imagine going into a bookstore and you pick up a book and then you set it down and you pick up another book. That's normal. And you see different sections of books and that's that. What the algorithm does is so different and so creepy. The algorithm is watching our children watching it. So what happens is imagine with an algorithm, you go into a bookstore, you pick up the first book, and it has to do with rainbows and the color blue, and what does that mean? And if you look at it for too long, all of a sudden, all of the books behind it change in the bookstore, and they tailor themselves to be something that it thinks you want to see, because these algorithms are made to keep people on the apps, especially children. And children who have vulnerable brains don't have the self-regulation skills to get out once they're pulled in. It's really hard for them. So the algorithm sees what they like and shows them more, or sees what keeps them there and shows them more. Even when the algorithm is showing them something scary or something they don't like, the algorithm is designed to keep them there. The algorithm has no morals. The algorithm doesn't care. The algorithm is made to keep them there, and it's horrifying.
Thank you, Senator Moody.
This hearing became far more than a policy discussion. It turned into a direct accusation against big tech and the lawmakers Moody believes are standing in the way of reform. Drawing from her experience as Florida's Attorney General and as a mother, Moody framed the issue as a crisis unfolding faster than society can handle. She argued that children are being exposed to dangerous technologies before parents or lawmakers fully understand the consequences. What made Moody's remarks especially powerful was her focus on how social media companies allegedly engineer addiction. She accused platforms of deliberately using endless scrolling, autoplay, targeted algorithms, and notifications to maximize engagement from children. According to Moody, these companies are not simply offering products, they are building systems specifically designed to keep kids online as long as possible because more screen time means more profit. The hearing intensified when Moody attacked the legal defenses used by tech companies. She argued that platforms are hiding behind Section 230 and First Amendment protections to avoid accountability. Her criticism was especially sharp when she claimed these corporations are effectively arguing they have a legal right to continue practices that harm children. That framing transformed the debate from a technical legal argument into a moral and emotional confrontation. One of the most compelling moments came when witnesses described how algorithms operate. The comparison to a bookstore changing every book around a child based on what they briefly looked at painted a disturbing picture of how recommendation systems function. Moody and the witnesses emphasized that children often are not actively searching for harmful content. Instead, algorithms continuously feed them material designed to keep them emotionally engaged, regardless of the consequences. By the end of the hearing, Moody's frustration with Congress was unmistakable. Her line, "If you're not going to join us in this fight, just get out of our way," became the defining moment of the exchange. Supporters will likely see her comments as a long overdue stand against corporate power, while critics may argue the proposals could raise concerns about speech and regulation. Either way, the hearing underscored how rapidly the debate over children, social media, and government oversight is escalating.